In part one, I'm going to speak about litigation, that is, past and present litigation. And the first case I'm going to speak to is the Enjoy case, which was really Sottera Incorporated versus FDA. That's Sottera Incorporated versus FDA. It's in 627 Federal Reporter 3rd edition 891 District of Columbia Circuit Court in the year of 2011. And I wrote down some notes, and then I'll speak to those notes. And this is right out of the case. The FDA can only regulate e-cigarettes as a tobacco product unless they are being marketed as a cessation device. Cessation. That's C-E-S-S-A-T-I-O-N. On April 15, 2009, the FDA denied the import into the U.S. of electronic cigarettes and accessories made by Smoking Everywhere and Enjoy. On January 14, 2010, the court granted the motion for preliminary injunction and entered judgment in favor of Smoking Everywhere and Enjoy. Senior Circuit Court Judge Stephen Williams affirmed the district court's ruling that electronic cigarettes can be regulated solely as tobacco products. The FDA decided not to appeal the decision to the Supreme Court and instead issued a statement of its intent to regulate e-cigarettes as a tobacco product. Now, what happened was Enjoy had electronic cigarettes come into America. The FDA put a ban on those imports, stopped those imports from coming into America, or into the U.S. So Enjoy, or the parent company, Sottera, I don't know if I pronounced that right, Sottera, what they did was they took the FDA to court. And even though they're a foreign country, they can actually sue in federal court, in the U.S. District Court. I mean, they actually have jurisdiction, even though they're a foreign entity. So they went through a period of time there, as you could see. It was in 2011. It was filed in 2009, and then it was ruled upon in 2009 in the circuit court when it went to appeal. And what it basically stated is that the FDA didn't have the power at that time to ban these imports from coming into the U.S. Now, also during this period of time, you had the Tobacco Control Act of 2009 get passed into law. And I'll be speaking to that in another part. And I am sure that Congress was well aware of this case that was going through the court. And I'm sure Congress definitely wanted to empower the FDA to regulate tobacco. So that's the reason why the FDA not only lifted the ban on the imports, but they also decided not to appeal the decision to the Supreme Court, because they didn't have the regulatory powers to regulate tobacco products. So in turn, what happens is the Congress gives that power to the FDA during the same time of this lawsuit going on with the Tobacco Control Act 2009. And that's how the FDA actually was able to get these powers that they have. It was based upon having lost in this case here with the Sottera Incorporated versus FDA. They lost that case, which the FDA, the commissioner probably said to themselves, well, I'm not going to let this happen here. And they started to consult with Congress, and that's where you came up with the Tobacco Control Act of 2009. So that's what happened pretty much in that case. Now, there's another case called, and by the way, all these cases that I cite outside of the Nicopure lawsuit, which is in present time in 2016, but all these past cases that I cite are actually in the FDA final rule. So whenever I speak to anything that I read to in any of the notes that I've taken down on paper or that I read from on the PDF or Word document files, are all related, or cited, I should say, or all cited in the FDA final rule. Because everything, when I put this together, I wanted to make sure that it all pertains to the FDA final rule. So anyway, there's another law case that came around in 2012. It was called Discount Tobacco City and Lottery Incorporated versus United States. 674 Federal Reporter, 3rd edition, 509, 6th Circuit, 2012. And this is what it reads. It's exactly from the case. The Tobacco Control Act's graphic warning and other requirements upheld. On August 31st, 2009, 6 tobacco manufacturers and retailers filed suit. On March 19, 2012, the Court of Appeals held in a 2-1 decision that the graphic warning label requirements did not violate the First Amendment. I can't pronounce this for the life of me, but it's ZAUDERER standard. It's a certain standard that the court goes by. It was a former case before this particular case here. And that standard states, graphic warnings as compelled disclosures of factual information preventing consumer deception. The restriction on any imagery and color being used in tobacco advertising, however, failed on this no more restrictive than necessary analysis. Okay, so I know that went right over your head, so let me explain that. What this was about was Discount Tobacco City. They had these tobacco products, these packages. And what the FDA wanted to do was they wanted to have certain labeling requirements on those packages. And Discount Tobacco City said, wait, hold it here, I could print anything I like on these packages because of it, according to the First Amendment of the U.S. Constitution. It's my way of expressing myself, or it's my freedom of speech. So, of course, they took the FDA to court, or actually, they didn't really even take they did take the FDA to court, but they really took the United States to court, which is /FDA. And what happened there was, what the court ruled on was that on the graphic warnings of cigarette packages, as long as the information on the packages are factual information, then the United States government did not violate the First Amendment. But then it went on to say, as long as it doesn't prevent consumer deception, because as long as there's factual information on those tobacco packages, or it could be any kind of packages for that matter, because this pretty much will wind up, across the board, so to speak, on other packaging as well, or even advertisements for that matter. As long as it doesn't create or prevent consumer deception. So in other words, as long as someone reads the tobacco package and it says lights, for instance. Well, the tobacco companies actually lost out on that. And that sort of bleeds into the FDA final rule as well. And that is, they didn't do any measurements, scientific analysis to show that these cigarettes are actually light. That even though they're light, because of the filter that's put inside the cigarette, the tobacco in the cigarette will still kill you, because it's the tar, it's the combusted ingredients of the tobacco that actually will kill you. It's not so much it's definitely the tar, of course, but it's actually the combusted aspect, and I'll get into that when I do that other section with chemistry. It's actually the combusted material, the compounds that are created from the combustion of the cigarette, that actually winds up with like plus 4,000 different chemicals, different compounds. And so that you can't say it's light. So even though they're saying, well, I have freedom of speech, you can't say something that will possibly deceive the general public. And so that's the reason why the U.S. government won on that. And I certainly can understand that reasonable argument. Okay, but then it said the restriction on any imagery and color being used in tobacco advertising, however, failed on this no more restrictive than necessary analysis. And what that means is, what the FDA wanted to do at the time was they wanted to put like bad gums and rotten teeth and, all these bad images. Like in Canada, they're able to put these really nasty color images on their tobacco packages to try to deter people from buying those packages. But the court in the United States, the Sixth Circuit Court, said, no, wait, hold it here. It can't be no more restrictive than necessary. In other words, they have to put factual information on those tobacco packages, but you don't really need to show colored descriptions of and graphic descriptions of gums or bleeding and all this nasty stuff. So, because they can't be any more restrictive than necessary. In other words, they can't, what's the word I'm looking for? They can't, I guess that's the best way to say it, as the court said it, really. You just can't be so restrictive. In other words, you can't say, like for instance, King George, that we fought against in 1776, could do anything he wanted. Okay? So the king could actually say, yes, I'm going to put color imagery all over the tobacco packages. And guess what? No one could do anything about it. But in America, in the United States, because of the Constitution, the FDA / United States government is unable to just do whatever they like. And so they're restricted to only what is necessary. And that is, tell the consumer factual information so you don't deceive the consumer. And that's, necessary to do that, because you don't want to put something like light cigarettes on there when it's not light, because the combusted tobacco compounds will kill you anyway, or give you heart disease or whatever have you. Regardless of what type of filter you put on there, that tobacco is still combusted, and it's the combustion that actually creates all these 4,000 plus chemicals that wind up killing you. So, and not only that, the tobacco companies were unable to prove to the courts through scientific analysis that light cigarettes actually are better for you than full flavored cigarettes. So the court found or ruled on that factual information is necessary, but you don't have to go so far out of the ballpark to prove a point, because the factual information itself will prove the point. You don't have to put color imagery all over it with gums bleeding and all the teeth rotting out and all this other stuff on packages to get the point across that cigarettes are bad for your health. So that's that particular ruling there. So it was like it was sort of a split decision. It was like ruled for the government on one part, and then another part ruled in favor of the discount tobacco city. And they speak a lot about this in the FDA final rule, as well as in their judicial complaint. And then there's another lawsuit called R.J. Reynolds Tobacco Company versus FDA. And it's 696 Federal Reporter, 3rd edition, 1205, District of Columbia Circuit Court in 2012. And this is what it reads. It says, the FDA's graphic warning rule struck down. On August 16, 2011, R.J. Reynolds, LORILLARD, Commonwealth Brands, Legit Group, Santa Fe Natural, filed suit. On February 29, 2012, the district court held that the graphic warning depicting the negative health consequences of smoking, including color graphics, rule violated the tobacco company's First Amendment rights. In other words, as I just explained, and this is pretty much the same time that Discount City company also sued, and it prevented the FDA from putting those nasty color images on the cigarette packages. And this is pretty much was it as far as the FDA. Now the FDA was thinking, well, as you read more into the lawsuit, the FDA was thinking of someday we'll figure out a way so we can do the color graphics on do it a different way or somehow or another, but they never did it because they'd be taken to court again and they lose. So that's basically, this is the case that actually solidified the fact that the FDA could not put on those color images on tobacco packages or any packages for that matter, including vaping products as well, though of course they were not speaking in terms of vaping products as far as this lawsuit is concerned at the time when it was filed and processed through the court as it was adjudicated. But nevertheless, they cannot do that at all, ever, forever, because a court will just use this one case as legal precedence and pretty much strike it down. So, yeah, color graphics. So, in other words, like maybe in vaping products, I don't know, though I don't know who would have a problem with vaping, but if there was some kind of imagery of a vapor having some kind of problem physically, the FDA couldn't put that image onto a vaping e-liquid or vaping hardware box or package or anything. They're prevented from doing that. And that's that case. And then there's another case called U.S. versus Philip Morris USA Incorporated. 686 Federal Reporter, 3rd edition, 832, District of Columbia Circuit Court, 2012. And this is what it reads in that case. Tobacco Control Act does not render RICO remedies moot. On September 22, 1999, the U.S. Department of Justice sued tobacco companies. U.S. District Court issued an opinion holding the tobacco companies liable for violating RICO due to their participation in a decades-long scheme to defraud the public about the health risks and addictiveness of smoking. In June 2009, the Tobacco Control Act was signed into law. So, apparently over a very, very long time, decades, like they said, I mean, as long as, they've been smoking in America, especially in regards to these particular tobacco companies, especially in terms of Philip Morris USA Incorporated, for decades they were pretty much deceiving the American public as to the health problems that you will get from smoking cigarettes. And because it was such a long period of time, and the Philip Morris USA Incorporated intentionally deceived the public as to the health risks involved with smoking cigarettes, that they actually were able to win as far as stating that they have violated the RICO statute, which is basically a racketeering statute that's actually used against the mob. But it could be used for anything, really. It depends on how you put your case together, because it's such a long period of time, and it's an organized effort by whatever company it may be or organization it may be. It's over a very long period of time that they deceive intentionally and hurt physically. That is, like, people died from smoking cigarettes for decades, and the tobacco companies knew about that, especially Philip Morris USA Incorporated, and yet they continue to sell these tobacco products with the knowledge that they're going to kill someone. And so the court held that they violated the RICO statute. I don't know if anyone ever went to jail over that, but I'm sure they paid a lot of penalties. And then, see, I think I have one more. Yeah, then one more case from the past, or recent past, I should say. Lorillard, Lord, I guess how you say that? Lorilllard Incorporated versus FDA. Number 11-440 RJL, that's RJ Reynolds and Lorillard, 2012 WL354228 in the District Court of Columbia, August 1st, 2012. And this is what it reads. Tobacco Products Scientific Advisory Committee composition can be challenged. On February 21st, 2011, Lorillard and R.J. Reynolds filed suit. The Tobacco Products Scientific Advisory Committee removal of menthol cigarettes from the market. On July 21st, 2014, Judge Leon granted the tobacco industry's summary judgment motion, stating that the FDA erred in concluding that the three challenged members of the Tobacco Products Scientific Advisory Committee did not have financial and appearance conflicts of interest. So what that was about was the Tobacco Products Scientific Advisory Committee, which is within the FDA, wanted to remove menthol cigarettes from the market. And it was really, I would say, almost like almost a technicality. The FDA lost on this case because they didn't really speak to the merits of the menthol cigarettes, how bad they are or whatever. And I smoked Marlboro menthol box shorts for at least 20 years, at least. Then I smoked Newports and some other cigarettes over time. I smoked from the time I was 17 17 years old to the time I was 52 years old. But for the most part, it was Marlboro menthol box shorts. Sometimes I would also smoke the cool menthol box cigarettes as well, and all that. So anyway, the FDA wanted to ban the menthol cigarettes, but before they could get to the merits, what happened was at the Tobacco Products Scientific Advisory Committee, there was a financial conflict of interest. And therefore, through that summary judgment, they didn't really have to, all they had to do was adjudicate on the law itself. And the law was definitely in the favor of the tobacco companies, because the Tobacco Products Scientific Advisory Committee violated the law by having a conflict of interest, financially as well as appearance-wise. So they pretty much ruled against the FDA on that. It was really a technicality. Like I said, they never got to the merits of the case. But anyway, that's that. But that was cited. That case was actually cited in the FDA final rule. Now, and I want to speak to a present case that's going on now. And that is Nicopure versus FDA. Case 1:16-CV-00878, District Court of District of Columbia. And this is what it reads for the most part. It's mainly in the section of relief, but it really sums up what their lawsuit's about. It states, vacate and set aside the deeming rule. The deeming rule is contrary to and exceeds FDA's statutory authority under the Act and the Federal Food, Drug, and Cosmetic Act. The deeming rule is arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with law. The deeming rule is the deeming rule's cost-benefit analysis is unlawful. The deeming rule is contrary to the First Amendment. And actually, when I read, in part, when I do Part 6, the FDA Final Rule 2016, I'll actually speak to most of this that's contained in this lawsuit with Nicopure versus FDA. Now, what they're basically saying is that the FDA abused their powers, that they went overboard with their powers. They overstepped their powers, which they did, by the way. And I'll get into all that when I read the FDA Final Rule. But anyway, the main key in this, and I spoke about this in another video called Nicopure Judicial Complaint, and that the main line in there is, or the phrasing, I should say, is an abuse of discretion. And actually, in fact, when I read to you, when I read Part 9 called FDA Executive Orders, they actually speak to the fact that federal agencies cannot have an abuse of discretion. And those executive orders are actually coming from the president. So, but anyway, an abuse of power, abuse of discretion is that the FDA could deem anything they wanted as a tobacco product, like they did with the vaping community under the FDA Final Rule. And they went way overboard with it. They went completely, in fact, when I read that last Part 9 FDA Executive Orders, it'll put everything pretty much in perspective, because the executive orders themselves actually say that federal agencies cannot be arbitrary, they can't be capricious, they can't have an abuse of discretion. And this is directed, executive orders are basically directives from the president on down to the federal agencies on how they need to conduct their business within the federal government. And so, by saying it's an abuse of discretion, one person in the Health and Human Services Department, meaning the secretary, cannot herself deem anything she likes. She has to be reasonable. She has to have scientific data, and this is all. When I read the other parts to this project here, I'll speak to all that so you can understand it better. But she can't just decide, well, this is how it's going to be. It has to be in accordance with the law. Now, like I said before in the prologue, the FDA Final Rule is very much based on the Tobacco Control Act of 2009. But there's nothing in the Tobacco Control Act of 2009 that states anything about vaping products whatsoever. Nothing. Zero, zilch, zero. But there's a phrase in there when I speak to that particular part that I'm going to speak to in another video. There's a part in there that allows her to deem anything she likes under her enabling powers. Now, I'm going to get into that. It's very interesting. Enabling powers. And that's where the gray area is at. Because I'll speak to it a little bit right now. What it does is those enabling powers, and only certain agencies have this, and FDA does have this power. And what it does is it permits the FDA not only to regulate industries, but actually enforce the regulation. In other words, they will have either the FBI, ATF, United States Department of Justice, maybe even the Homeland Security as far as imports into America from vaping industries across the seas or oceans or whatever have you, or South America or Mexico, or no, I don't think any vaping products come from there, but anyway. But the thing is she actually has the power to actually enforce the regulations, because she has this, it's called an enabling, that's ENABLING power. And that's given to her or to the FDA by the president. Yeah, understand? And not only that, not only by the president, but also by Congress. And that gives her a lot of power. Because when she deems something as tobacco, like she did with the electronic nicotine delivery system, the ENDS, or this e-cigarette as we know it, with that deeming power, or like they say here, the deeming rule in the Nicopure case, not only, like I said, can she regulate the vaping industry, but she can actually enforce it as well. In other words, she has police powers. You understand? And I'm not talking about police officers. I'm talking about police powers, meaning that she has the power to enforce those regulations, to actually have raids, to actually shut people down, to actually seize products, to actually take it to court. Actually, when I get into the FDA final rule, they speak to criminal prosecution as well as civil penalties. And they have the power to do that themselves within the FDA. That's how much power they have. So what Nicopure is doing is they're saying, wait, hold it here. This deeming rule has given the FDA way too much power. No federal agency in America should have that type of power. And the FDA, there's like 4 or 5 other federal agencies that also have that type of power. But what Nicopure is saying is that the deeming rule is basically unconstitutional, is what they're saying. And eventually it'll wind up in the U.S. Supreme Court. And it is. And I always wanted someone to actually go after that deeming clause. I spoke about that in another video. I think it was called Deeming Clause is Unconstitutional, something like that. Challenge deeming clause is unconstitutional, something like that. Which it is. Because now, one person should not have that type of power. The power is vested in Congress, not in one person in the federal government. Understand? Because she's like a queen, is what she is. She could dictate however she likes. As soon as she gives the notice of the public rulemaking process to the public, meaning the like public notices, like as far as the public comments that we had throughout 2015, they had workshops, they had industry would come, and industry owners or representatives would come and meet with the FDA and explain themselves and why they shouldn't have an FDA final rule come down so in a strict manner and all this other stuff. But she was just going through the motions because she had to do that under the statute of the Tobacco Control Act, as well as the presidential executive orders, as well as the what was the other thing, real quick, as well as the Administrative Procedures Act. She actually has to do that, or he, could be a he someday, I don't know. Right now it's a she. She actually has to follow that process through the public notice and have public participation. But she was just going through it as a technical process. She didn't even, in fact, when you read the FDA final rule, she took all the information, and there were many more comments than what she spoke to in the FDA final rule that was submitted throughout 2015 during all that public meetings and all that public comment and everything. And she just picked and chose, along with the Office of Management and Budget and the Office of Internal Regulatory Affairs. They pretty much picked and chose what they wanted to put in that FDA final rule that suited their own agenda. Absolutely, absolutely. And when I read that FDA final rule and explain it to you, you understand. So the great thing about the Nicopure is they're actually going after the deeming rule as unconstitutional because she has way too much power. That much power should not be invested in one person. That power is only really invested in Congress, which is the representative, the body politic of Congress is the representative of the people. Because ultimately the people have the power. That's if you organize and unify behind one cause or one issue or whatever have you. The people, the Americans, have ultimately the power. The ultimate power. Actually more power than the president. If all the Americans get together, and I'm not just talking about 5 or 10, I'm talking about like 225 million Americans get together behind one cause, yeah, the president has absolutely no power. He can't do nothing. His hands are tied, or her hands are tied. So, that is what the Nicopure is all about, is challenging that deeming rule as unconstitutional, or not in accordance with law, as it says. And that abuse of discretion, meaning that she used her discretion and abused it. She went way overboard in her analysis and her determinations and in her conclusions of this FDA final rule. She went way overboard. And I'll actually speak to that when I get into the FDA final rule, because you will see what that's all about, and that is just insane. It's just completely, it's unheard of what they did. In fact, you know, in that lawsuit I was talking about before, you could probably even cite this in a case against the FDA. In the U.S. versus Philip Morris USA Incorporated, it says violating RICO due to their participation in a decades-long scheme to defraud the public. You know, you could actually file a RICO lawsuit against the FDA because they have participated in many decades. It's not just the vaping. You know, I just saw a video on food, on the food industry, that somebody put up in the comments section under one of the videos on this channel, how they did it with the food industry, how they did it with the drug industry, how they did it with the cosmetic industry. They for decades long they've been doing this crap. If it's not the food industry or the dietary supplements, what was that video all about? Was dietary supplements. If they aren't doing it against those particular companies, they're doing it against the vaping community. They are just way overboard on everything they do. And basically they are defrauding the public because they have no scientific evidence that vaping is bad for your health, and yet they're making it appear that vaping is absolutely no different than smoking an analog cigarette, a combusted cigarette, which is it's just completely insane. It's unreasonable, and like Nicopure stated, it's arbitrary, it's capricious, it's an abuse of discretion. It's just unheard of. And I'm very happy that the Nicopure, I really am looking forward to hopefully seeing that Nicopure see its way through to a victory, because I know there's other lawsuits. There's a Lost Art Liquids lawsuit. Now, I would read from that, but I can't find that anywhere online. So it's up to Lost Art Liquids if they want to publish their complaint online. And then there's Kellerman Law Firm that also is going to be filing something on behalf of, I think, Safada, AMSA, and so what was the other one? There's another one, but there's a few companies that are getting together and filing this lawsuit with the Kellerman law firm, and I'm sure that's going to be a biggie as well. And hopefully, if I can get the complaint or any motions or response or even a reply out of that lawsuit, I will definitely speak to that in a separate video. But right now, presently, we have the Nicopure versus FDA, and I really hope that this one does justice for the vaping community / industry, because no person should have that. No individual person should have that type of power. No one should. And when I read the FDA final rule, you'll see what it's all about, and it's insane. It's like she's the Queen of America. You know, you have the Queen of England. I'm not talking about the Queen of England of 2016. I'm talking about the Queen of England of the maybe the 1300s, or the 1500s, or the 1400s, or the 1600s, even the 1700s. Those queens and kings had serious power. Well, that's basically what the Queen of the FDA is also all about. She has that type of power. So anyway, so this is my part 1 called Past and Present Litigation, and I'm sure there's other cases going to be filed, and I'll speak to them in other videos outside of this project that I'm doing. But I just wanted to give you an idea that there have been cases in the court system already in the recent years that have challenged the FDA on the things that the FDA had wanted to do, especially when it comes to First Amendment. I mean, their FDA is literally stripping, or they try to strip companies of their First Amendment rights under the U.S. Constitution as far as freedom of speech is concerned. And as you saw, they had lost. And for the most part, they lost those cases. They won on a little bit on some, but for the most part, they lost. And so, based upon those cases, as well as other cases that, like Nicopure or Lost Art Liquids or Kellerman law firm will cite in their cases, you'll see it'll all come together in these lawsuits against the FDA. It'll take some time for these lawsuits to go through the court process. I mean, I see a year, 2 years, maybe even 3 years before it's actually fully adjudicated. That is, either it goes to appellate court or it even goes to the U.S. Supreme Court if they're willing to hear it. And if they go to the U.S. Supreme Court, probably about 2-3 years before you actually get a decision on that. That's why we have to also stay with the legislation. You have the Cole-Bishop Amendment and any other legislation that comes after that, and that will stall the process as far as the FDA final rule is concerned while all these litigated cases go on. So it's like a two-pronged kind of action that we're doing against the FDA. That has to be done like that. It has to be done that way. But anyway, so that's my part 1, and then I'm going to get into part 2, which is the FDA contracts, which probably due later on tonight or so. It's 11:17 p.m. right now, so probably do that maybe in a couple 2-3 hours or so, because that's pretty long. That particular area, I have to read a lot of documents. So anyway, this is my part 1. Hopefully you got something out of it. Put some things in perspective for you. And you guys have a good one. Bye.